Gary Plauche. On March 16, 1984, a man stood at a bank of payphones inside the Baton Rouge Metropolitan Airport. Wearing a ball cap and sunglasses, a .38 caliber revolver tucked into his right boot. He was on the phone with his best friend Jimmy, watching the terminal hallway, waiting. Then, on a live WBRZ television feed that was rolling for the extradition arrival, the moment came. Two East Baton Rouge Parish Sheriff's deputies walked a handcuffed man named Jeffrey Doucette through the terminal, returning him from California. Gary Plauche turned from the phone, drew the snub-nosed revolver, and fired a single hollow-point round into the right side of Doucette's head from roughly 3 feet away. Doucette collapsed, fell into a coma, and died the following morning, March 17th. The footage aired on local television that same night. And the reason it still circulates over 40 years later is not just the act itself. It is what happened before and what the court decided afterward. Baton Rouge, Louisiana, early 1984. Gary Plauche was a heavy equipment salesman, separated from his wife June and the father of a boy named Jody. Jody had been studying karate under an instructor named Jeffrey Doucette, who had built a close relationship with the family over the course of several years. What Plauche did not know was that Doucette had been systematically grooming and abusing his son during that time. In February of 1984, Doucette took Jody by bus from Port Arthur, Texas, all the way to Anaheim, California, without the family's knowledge. The boy was missing for 10 days. When Doucette finally allowed Jody to call his mother Colette from a motel room, police traced the call and moved in. A forensic examination confirmed that Doucette had abused Jody during the trip. On the return flight to Louisiana, Doucette voluntarily confessed to investigators that his misconduct extended beyond Jody to other children as well. He was being brought back to face charges in Baton Rouge. He never made it past the terminal. The tipster who told Plauche when Doucette's extradition flight would arrive was a former colleague from WBRZ, where Plauche had once worked as a television camera operator before moving into equipment sales. He drove to the airport, positioned himself at the payphones, and the last thing he said into the receiver before turning around was that his friend was about to hear a shot. Plauche was immediately restrained and arrested. Deputies Mike Barnett and Bud Connor, the same officers escorting Doucette, secured Plauche at the scene. He was initially charged with second-degree murder, which in Louisiana carried a mandatory life sentence. The question the prosecution faced was whether a jury would convict a father under those circumstances, with that footage on every local newscast in the state. A psychiatrist named Edward Uzzi evaluated Plauche and concluded that he could not distinguish right from wrong at the moment he pulled the trigger, supporting a defense of temporary psychotic state. Rather than take the case to trial, Plauche entered a plea of no contest to a reduced charge of manslaughter. In 1985, Judge Frank Saya handed down a sentence that stunned both sides of the debate. 7 years, fully suspended, 5 years of supervised probation, 300 hours of community service. That's not a typo, by the way. The man who took a life on live television in front of 2 law enforcement officers walked out of that courtroom without a single day of incarceration. Judge Saya stated on the record that sending Plauche to prison would not serve any purpose, and that he posed virtually no danger of reoffending. No appeals were filed. Plauche completed his community service by 1989, most of it spent cutting grass at his church. He suffered a stroke in 2011 and passed away on October 20th, 2014, at the age of 68. The airport footage of the shooting has since appeared in multiple documentaries, including Michael Moore's 2002 film, Bowling for Columbine. His son Jody, now in his 50s, grew up to become a sexual abuse awareness activist. He served on the Men Against Violence board at LSU. worked with the Victim Services Center of Montgomery County, Pennsylvania, and in August of 2019, published a memoir about his experience. The boy whose father took a life for him spent his adult years making sure other children did not have to wait for someone to act. Gary Plosh never served a single day behind bars. The same legal system that was meant to protect his son had already failed once before, when Doucette's pattern of abusing children went largely unpunished. 9 years later, in a courthouse 3,000 miles to the west, another parent reached the same breaking point. Except she did not wait for a terminal hallway. She did it inside the courtroom itself. Ellie Nessler. On April 2, 1993, in the Tuolumne County Superior Court in Jamestown, California, a woman named Ellie Nessler sat through the preliminary hearing of a man named Daniel Mark Driver. Driver was facing charges of abusing 4 boys, including Nessler's son Willie. During a recess, Driver looked in the direction of her son outside the courtroom and smirked. What nobody knew at that moment was that Nessler's sister, Jeanette Martinez, had a .25 caliber pistol in her purse sitting on the bench beside them. Nessler grabbed it. She walked up behind Driver, who was still in handcuffs, and fired 5 rounds into the back of his head from 2 to 3 feet away. A 6th round struck the courtroom wall. Driver died instantly. Groveland, California, late 1980s. Ellie Nessler was raising her son Willie largely on her own. The daughter of a gold miner, a single mother whose own past included abuse she experienced as a young woman. Willie had disclosed that Driver had been harming him, and that Driver had threatened to take the lives of Willie, his sister, and his mother if the boy ever said a word. The toll on Willie was severe. He became deeply anxious, once asked his mother about ending his own life, and was found on another occasion holding a firearm. Driver already had a 1983 felony conviction for child abuse out of Santa Clara County, for which he had served only 5 months. He fled the Tuolumne County area in 1989 and was not apprehended until late 1992. When he was finally brought back for his hearing, Nessler sat in that courtroom carrying years of fear and fury that had never had anywhere to go. What prosecutors would later reveal is that she was under the influence of methamphetamine the day she fired those shots. That fact, along with a prior auto theft conviction, significantly complicated the public sympathy she initially received, until it did. Her defense attorney, J. Tony Serra, built the case around a theory of temporary insanity. The trial began on July 12, 1993, before Judge James Wheeler in Sonora. The prosecution pushed for first-degree murder, arguing premeditation. On August 12th, the jury convicted her of voluntary manslaughter with a firearm enhancement, rejecting the murder charge entirely. A bifurcated sanity phase followed, and on September 29th, the panel found her legally sane. On January 7th, 1994, Judge Douglas Moss sentenced her to 10 years in state prison. This is where the story takes a turn nobody expected. In August of 1997, the California Supreme Court issued its ruling in People v. Nessler. The justices upheld her guilt phase conviction, meaning the manslaughter verdict stood, but they reversed the sanity finding entirely. The reason was juror misconduct. During the sanity deliberations, a juror named Linda Boge had introduced outside information she had picked up during a conversation at a bar, specifically claims about Nessler's drug use and questions about her fitness as a parent. That information had not been presented at trial, had not been subject to cross-examination, and had no place in the jury room. The appellate court agreed. Rather than face a retrial on the sanity question, Nessler negotiated a deal. On October 1st, 1997, she pleaded guilty to voluntary manslaughter and withdrew the insanity plea entirely. She walked out of court that same afternoon, a free woman, after serving nearly 4 years. The freedom did not hold. In 2002, Nesler was convicted of selling and possessing methamphetamine and sentenced to 6 years. She served her time at the Chowchilla Women's Facility and was released in 2006. She had first been diagnosed with breast cancer back in 1994 while incarcerated. On December 26, 2008, Ellie Nesler died at UC Davis Medical Center at the age of 56. You would think someone would have stepped in for Willie along the way. Nobody did. Her son William was convicted in 2005 of taking a man's life in Sonora and is currently serving 25 years to life. The case became the basis for a 1999 USA Network film. But the real weight of the Nesler story is not the courtroom footage or the legal reversals. It is the fact that a family shattered by one man's actions never reassembled, no matter what the mother did to try to stop it. Up to this point, both Plausch and Nesler had acted in American courtrooms, in a system where juries could weigh provocation, diminished capacity, and a parent's state of mind. In West Germany, in 1981, another mother walked into a courtroom under an entirely different set of laws and precedents. And she brought a Beretta. Marianne Bachmeier. If you had asked anyone in Lübeck, West Germany, about Marianne Bachmeier in the spring of 1980, they would have told you she was a single mother who ran a pub called Tepasa and was raising a 7-year-old daughter named Anna. They had no idea that within a year, Bachmeier would become one of the most divisive defendants in the country's post-war history. On May 5, 1980, Anna Bachmeier skipped school after an argument with her mother. She wandered into the path of a man named Klaus Grabowski, who lived nearby. Grabowski was a 35-year-old butcher and a convicted offender with a documented history of harming children. He had been sentenced for abusing 2 girls years earlier and undergone chemical castration in 1976 as part of that sentence. But West German doctors had later authorized hormone treatments that reversed the procedure entirely, a decision that Grabowski's own defense would later cite as a destabilizing factor. He abducted Anna that afternoon, held her for hours in his apartment, and took her life. Her remains were recovered nearby. She was 7 years old. That was the spring of 1980. By March 6, 1981, Grabowski was standing trial in room 157 of the Lübeck District Court. Bachmeier attended the proceedings. On the 3rd morning of the trial, she smuggled a Beretta 70, a .22 caliber pistol, into the courtroom. Around 10 in the morning, she rose from the gallery and fired 7 or 8 rounds into Grabowski's back. 6 bullets struck him. He died almost immediately. Witnesses in the courtroom heard her say afterward that he had taken her daughter, that she had wanted to shoot him in the face but ended up shooting him in the back, and that she hoped he was gone. Bachmeier's background became central to the public's reaction. She was born in Sarstedt to East Prussian refugees. She became pregnant at 16 and again at 18, the second time following an assault. Both of those children were given up for adoption. Anna was her 3rd daughter, the one she kept, the one she was determined to raise. A later ARD documentary from 2006 revealed that Bachmeier had rehearsed firing the weapon in the basement of her pub in the days before she brought it to court. In other words, this was not a spontaneous act. She practiced. She was charged with murder in November of 1982. Prosecutors argued premeditation, pointing to the rehearsal evidence and the fact that she had smuggled the weapon past court security with apparent forethought. But the murder charge was eventually reduced. Her trial ran 28 court days and became a national event in West Germany, with the public deeply divided. Some saw her as a grieving mother, driven past the limit of what any parent could bear. Others argued that if courtroom vigilantism were tolerated, the justice system would collapse. On March 2, 1983, the Lübeck District Court convicted her of manslaughter and unlawful possession of a firearm. She was sentenced to 6 years. She served 3. To cover her legal costs, she sold her life story to the magazine Stern for approximately 100,000 Deutsche Marks. The filmmaker Hark Bohm released a dramatization in 1984 titled No Time for Tears. After her release, Bachmeier married a teacher in 1985 and moved with him to Lagos, Nigeria in 1988. The marriage ended in 1990. She relocated to Palermo, Sicily, where she took work as a hospice aide. On September 21, 1995, she appeared on the ARD talk show Fliege and admitted publicly, for the first time, what she had done and why. She was by then already ill. Diagnosed with pancreatic cancer, she returned to Germany. She passed away on September 17, 1996, at the age of 46, in a hospital in Lübeck. She is buried beside Anna in Bergtor Cemetery. He took her daughter's life and was never sentenced for it because he never survived his own trial. She took his and served 3 years. The court weighed those facts and moved on, but the public never did. Decades later, her case is still taught in German law schools as the most prominent example of courtroom vigilante justice in the country's modern history. Bachmeier acted alone, at arm's length, inside a courtroom where the man who destroyed her family sat in front of her. The father you are about to hear about had no such proximity. His daughter's abuser was protected by an international border, 2 competing legal systems, and 27 years of procedural obstruction. Andrzej Bamberski. In the summer of 1982, a 14-year-old girl named Kalinka Bamberski was staying at her mother's home in Lindau, Bavaria, with her stepfather, a German cardiologist named Dieter Krombach. On the morning of July 10th, Kalinka was found dead. Krombach told investigators she had died from heat stroke, possibly aggravated by a car accident from years earlier. But the autopsy findings contradicted that explanation entirely. The examination revealed evidence consistent with a medical procedure performed without consent, and investigators noted irregularities in how the post-mortem itself had been conducted, including the unexplained removal of certain organs. Krombach admitted to administering a cobalt iron compound and a sedative to her. He described it as a treatment. Andrzej Bamberski, Kalinka's biological father, did not accept that explanation, and he would not stop pursuing the truth until someone answered for what happened to his daughter. No matter how many years it took, no matter how many governments stood in the way. 14 years before Krombach was finally brought to trial, Andrzej Bamberski was an ordinary father in France whose daughter had just died under circumstances that no physician could credibly explain. He filed complaints, petitioned prosecutors, hired investigators. German authorities reviewed the evidence and declined to bring charges. France tried Krombach in absentia in 1995 and secured a conviction, but the European Court of Human Rights overturned it in 2001 because Krombach had not been provided legal representation at trial. Germany formally refused to extradite him in 2004. The legal architecture of 2 nations had effectively created a shield around one man. And somehow, it gets worse. In 1997, Krombach was convicted in Germany of drugging and assaulting a 16-year-old patient. He lost his medical license. A 2006 ARD documentary featured 2 teenage sisters who alleged that he had injected and assaulted them as well. Despite all of it, Krombach remained free, living in Bavaria, beyond the reach of French prosecutors. With the French statute of limitations approaching in 2012, Bamberski made a decision that would turn him from a grieving father into a defendant. He paid 19,000 euros to a team of men led by a man named Anton Krasniqi. On October 17, 2009, 3 of them confronted the 74-year-old Krombach at his home in Scheidegg, Bavaria. They beat him, drove him across the German-French border, and left him chained to a fence outside the Mulhouse police station with a fractured skull. It was, in the most literal sense, a delivery. Bamberski had brought the man France could not extradite directly to the doorstep of French law enforcement. He was arrested shortly after. Police recovered exactly 19,000 euros in cash from his hotel room safe. France refused Germany's extradition demands for Bamberski. And with Krombach now physically present on French soil, prosecutors did what 27 years of cross-border diplomacy had failed to accomplish. They put him on trial. In October of 2011, a Paris court convicted Krombach of intentional bodily harm, resulting in unintentional death, and sentenced him to 15 years in prison. Krombach's attorneys mounted appeal after appeal. The appeals court confirmed the verdict in December of 2012. The Court of Cassation, France's highest court for criminal matters, rejected any further challenge in April of 2014. And when Krombach brought his case before the European Court of Human Rights on double jeopardy grounds, that too was dismissed in March of 2018. Every door he tried was closed. Krombach was briefly released on health grounds in 2016, but prosecutors successfully appealed and he was returned to custody. He was finally released in February of 2020 and died in a German care facility on September 12th of that year. Andrei Bamberski received a 1-year suspended sentence for the kidnapping. He never spent a night behind bars. The 2022 Netflix documentary My Daughter's Killer chronicles the full 27-year pursuit. Every parent in this video reached a point where they decided the system had failed them. But the final case in this half is different, because in this one, no legal system had the chance to fail. The father walked through his own front door and saw it happening. Jason Browning. On July 18, 2014, Jason Browning walked into his home in Daytona Beach, Florida, and found an 18-year-old man named Raymond Frolander in a bedroom with his 11-year-old son. Frolander was someone the family trusted, someone considered practically a relative, who lived next door with the boy's biological mother. At least, that is what the family believed about him. What the boy later told investigators was that Frolander had been abusing him for approximately 3 years, since the child was roughly 8 years old. Browning beat Frolander unconscious with his fists and dragged him from the bedroom into the living room. He picked up the phone, called 911, and told the Volusia County dispatcher in plain language that he had walked in on a grown man harming his child, and that the man was lying, knocked out on the floor in a puddle of blood, ready for officers to collect. He later described publicly what happened next. He went to the kitchen, picked up a butcher knife, and intended to end Frolander's life. His son stepped between them and stopped him. Browning said that his boys saved his attacker's life that night. Browning had his own history with this kind of harm, and that detail is essential to understanding the scene. He told reporters that he had been abused as a child while in a California foster home. This was not an abstract act of violence by an enraged stranger. This was a man responding to something he recognized from his own childhood, encountering it in his own home, being done to his own son. Daytona Beach Police Chief Mike Chitwood publicly stated that he had no issue with what Browning did. not as a law enforcement officer and not as a father. The state attorney's office reviewed the circumstances and the evidence collected by responding officers, including the boy's own disclosure, and declined to file any charges against Browning. He was never arrested, never indicted, never prosecuted. In the eyes of Florida law, he had acted within his rights as a parent defending his child from an ongoing assault. There was no grand jury, no internal review, no second guessing from the department. The case was closed on Browning's side before it ever opened. Browning later created a crowdfunding page, initially requesting $1 million, which he reduced to $100,000. Chief Chitwood openly criticized the campaign, arguing that it was inappropriate and could harm the child's recovery. The page was eventually removed. Frolander's case moved through the courts with no ambiguity. Investigators confirmed the boy's account and determined that the abuse had been ongoing for roughly 3 years, with Frolander taking advantage of his proximity to the family and his access to the child through the boy's biological mother's home next door. The evidence was not contested. Frolander pleaded no contest to a charge of lewd and lascivious abuse of a child under 12. On April 2, 2015, Volusia County Circuit Judge Leah Case sentenced him to exactly 25 years in Florida State Prison, followed by lifetime sex offender registration and lifetime supervised probation upon release. There was no plea bargain for reduced time. There was no early hearing. The full weight of the statute came down. After the sentencing, Browning told reporters that Frolander was going to learn in the next 25 years why he had let him live. As of today, Raymond Frolander remains incarcerated. Barring any early release, his projected release date is April 2, 2040. Jason Browning has had no further documented legal trouble. He was the only parent in this video who faced no charges, no trial, no suspended sentence, and no probation. The state looked at what he did and decided it was not a crime. The case remains one of the most widely cited examples in the ongoing public debate over where the boundary falls between a parent's instinct to protect their child and a citizen's decision to bypass the justice system entirely. For Browning, the line was never in question. The system did not fail him. He never gave it the chance to. If you like this video and have not subscribed yet, now is a great time to join. We post a new case every day, so hit subscribe and do not miss what is coming next. Fatmir Terralari. On January 7, 2024, a father in rural Greece named Fatmir Terralari received a phone call from his daughter's landlord in the city of Volos. The landlord said the rent had not been paid. Terralari, a 50-year-old Albanian national living in the village of Argalasti, called his 18-year-old daughter to ask why. She was a university student and had always managed her expenses without issue. But when he pressed her, she did not talk about money. She told him something else entirely. She told him that her uncle, a man named Erjan Pelevani, the brother of Terralari's second wife, had been abusing her since she was a child, that the abuse had escalated over the course of years, and that Pelevani was now blackmailing her with photographs and video, demanding money in exchange for his silence. A psychiatrist who later evaluated the daughter confirmed that she suffered from severe post-traumatic stress and had made at least one attempt to end her own life. 2 days later, on January 9, 2024, Terralari drove home, retrieved his legally owned hunting rifle, and arranged through his wife for Pelevani to meet him on a roadside near a cement factory outside Volos, under the pretense of helping with a flat tire. When Pelevani arrived, Terralari confronted him directly about what he had done to his daughter. According to Terralari's account, Pelevani responded with a smirk and lunged for the rifle. Terralari fired. Pelevani, 33 years old, was struck and died at the scene. Terralari did not flee. He surrendered to police through his lawyer shortly afterward. Nobody outside the family had been paying attention to this girl's situation. The abuse, according to her testimony, had begun when she was still in primary school and had escalated over the years. Her younger brother, now 9, had sometimes been present in the apartment during the assaults, locked in a separate room. The full scope of what she endured did not surface until that phone call about unpaid rent, a mundane detail that unraveled years of concealed trauma. Terralari was charged with intentional homicide in a calm state of mind, illegal use of a firearm, and possession without a permit. Under Greek law, the charges carried a potential life sentence with a mandatory minimum of 2 years. The case moved through several pre-trial stages. He was initially placed in temporary detention, then transferred to house arrest at his daughter's apartment, a ruling that was met with applause from family members present in court. He was subsequently remanded to a special ward of Larissa Prison on January 22, 2024. His attorney, Alexis Kougias, one of the most prominent criminal defense lawyers in Greece, argued that the act followed extreme provocation and that no reasonable father could have responded differently under those circumstances. Greek media covered the case with considerable sympathy for Terralari. And somehow, it gets worse. In the weeks following the arrest, investigators reviewing the evidence reportedly found indications that the daughter may have partially fabricated or exaggerated certain messages presented as evidence. That development has complicated the case without resolving it. As of early 2026, no final trial verdict has been issued. The case remains in the Greek judicial system, and the question of what exactly Pelaveni did and how much of the daughter's account will be corroborated is still being weighed by the courts. Terralari acted within hours of learning what he believed had been done to his daughter. Barry Gilton and Lupe Mercado had weeks to plan, and the fallout stretched across nearly a decade of federal court proceedings. Barry Gilton and Lupe Mercado. At 2 a.m. on June 4th, 2012, a 22-year-old man named Calvin Sneed was driving through the Bayview district of San Francisco near the intersection of Meade and LeConte Avenues. A silver Mercedes SUV pulled alongside him. Shots were fired into his vehicle, and Sneed was struck and died at the scene. He was a member of the Nutty Block Crips in Compton, and he had been trafficking the 17-year-old daughter of 2 people named Barry Gilton and Lupe Mercado. This story does not start with the shooting. It starts with a girl who ran away from home. The couple's daughter, identified in press reporting only by a pseudonym, had left her family's Bayview home and traveled to the Los Angeles area, where Sneed began advertising her in online sex ads and controlling her movements. Sneed had a tattoo across his hands that read, roughly paraphrased, that if something did not make money, it did not make sense. That was the world their daughter had disappeared into. When Gilton and Mercado learned what was happening to their child, the response was not a phone call to police. A first attempt was made on May 27, 2012, in North Hollywood. Sneed was wounded by shattered glass from the vehicle, but survived. 8 days later, on June 4th, when Sneed drove north to San Francisco to collect the daughter, who had returned to her parents' home, the second attempt succeeded. Barry Gilton was a former Muni driver on disability with a 1995 drug conviction and ties to a local organization known as the Central Divisadero Players, or CDP. Lupe Mercado was his high school sweetheart and the mother of their 4 children. What federal prosecutors would later argue was not an act of parental desperation, but a gang-affiliated racketeering operation. The defense framed as exactly the opposite. The case was initially charged in state court in 2012 with murder, conspiracy, and firearms counts. 2 years later, It was absorbed into a 22-count federal RICO indictment filed in August of 2014, covering 11 CDP defendants. The government's theory was that the killing of Sneed was not an act of parental rescue, but one node in a broader racketeering enterprise. Co-defendants Antonio Gilton, Barry's cousin, and Alfonso Williams pleaded guilty in May of 2019 to participating in Sneed's death, and were sentenced to 22 and 25 years, respectively. Other CDP members received sentences ranging from 6 years to 4 consecutive life terms. The scope of the indictment was enormous. Barry Gilton's trial began on February 3, 2020, before U.S. District Judge William Orrick. The trial lasted 4 weeks. Prosecutors presented testimony from cooperating witnesses, surveillance evidence, and Gilton's documented connections to the CDP. The defense argued that Gilton was a father acting to save his daughter from a violent pimp, not a gang member executing a racketeering hit. On February 25th, the jury reached its verdict. They convicted Gilton of racketeering conspiracy, but acquitted him of the actual charge that mattered most. He was found not guilty of Calvin Sneed's death and not guilty on all firearms counts. 5 months later, Judge Orrick went further. He granted a Rule 29 motion for judgment of acquittal and set aside the RICO conviction entirely, ruling that even though Gilton, in the judge's own assessment, undeniably participated in Sneed's death alongside 2 known CDP members, the evidence did not support the legal inference that Gilton intended a pattern of racketeering activity, which RICO requires. The Ninth Circuit affirmed that decision in January of 2022. Lupe Mercado was acquitted of the same charge. She was convicted only of accessory after the fact, a charge carrying a maximum of 15 years. Her sentence was time served. She was released in 2020 after roughly 7 years in federal custody. Gilton, who had spent approximately 7 years in pretrial detention, walked free with no federal convictions. And somehow, it gets worse, but not in the way you might expect. Gilton subsequently filed a civil rights lawsuit against the city and county of San Francisco. Judge Orrick dismissed it with prejudice in 2024. The parents who the public believed had taken justice into their own hands were, in the eyes of the law, not guilty of doing so. The jury agreed with the government's evidence that Gilton was present. The jury simply did not agree that it was enough for a conviction. The daughter survived. The pimp did not. And the only people held legally accountable for his death were 2 men who had nothing to do with being her parents. Gilton and Mercado's case was handled by the federal justice system, however imperfectly. What happened in Tamaulipas, Mexico, was something else entirely. There was no justice system to speak of. One mother became the investigation, the surveillance, and the informant, all by herself. Miriam Rodriguez. In January of 2012, in the town of San Fernando, Tamaulipas, a 20-year-old woman named Karen Alejandra Salinas Rodriguez was driving her pickup truck when 2 vehicles cornered her on the road. Armed men from Los Zetas, a paramilitary offshoot of the Gulf Cartel, forced her out of the cab and into one of their vehicles. Her family paid ransoms through a local bank that openly offered what it called ransom loans, a financial product designed specifically for kidnapping victims, because the practice was that common in that part of Mexico. This was not an anomaly. This was the economy of San Fernando, Tamaulipas. Karen was never returned. The money disappeared along with her. How does a small business owner in one of the most dangerous municipalities in the Western Hemisphere go from paying ransom to personally hunting down cartel operatives one by one? Miriam Elizabeth Rodriguez Martinez ran a cowboy apparel shop called Rodeo Boots in San Fernando. She was not trained in law enforcement, intelligence gathering, or surveillance. She had no institutional backing, no resources beyond her own ingenuity, and no protection from any government agency. When Karen's remains, including one femur and the scarf she had been wearing, were recovered at an abandoned ranch outside San Fernando in 2014, and DNA analysis confirmed the match in January of 2015, Miriam stopped grieving and started tracking. Over the next 3 years, she became her own investigative unit. She changed her hair color, posed as a healthcare worker conducting neighborhood surveys, impersonated election officials, and carried false identification and a handgun. She tracked one suspect through a tagged Facebook photograph, followed him home over the course of several days, and called police when her son Luis confirmed the sighting in Ciudad Victoria. She located an 18-year-old suspect at a chapel where he had become a born-again Christian and had him arrested on sight. She found the woman who had physically tortured Karen, a woman who had beaten her daughter as she hung from her wrists, hiding 500 miles away in Veracruz, driving a taxi under a false name. By 2017, Miriam had been directly responsible for the capture of 10 cartel members connected to Karen's abduction. She did not operate with backup or institutional support. She operated alone in a region where cartel informants saturated local law enforcement. She also founded the Colectivo de Desaparecidos de San Fernando, an organization for families of the disappeared. She told the New York Times that she did not care if they came for her, that she had already died the day they took her daughter. On March 22, 2017, approximately 29 inmates escaped from the Cadiz Ciudad Victoria prison. Among them were several men Miriam had helped put there. 6 weeks later, on May 10th, which was Mexican Mother's Day, gunmen forced their way into her San Fernando home and shot her 12 times. She died on the way to the hospital. She was 57 years old. Tamaulipas Attorney General Irving Barrios said police had been patrolling her home 3 times a day, but acknowledged the patrols had not prevented the attack. The legal aftermath has unfolded slowly and unevenly over the years that followed. In August of 2025, a Matamoros judge sentenced Enrique Joel Rubio Flores, a former Zeta, to 131 years, 6 months, and 3 days in prison for Karen's kidnapping, her death, and criminal association. It was the first major conviction in the case. Rubio Flores is also a suspect in Miriam's own assassination and is alleged to have been among those who escaped from Ciudad Victoria prison in March of 2017. 3 other captured suspects in Karen's case were released because they had committed the crimes as minors under Mexican law. One of them completed an 8-year sentence at the Santa Adelaida facility. As for Miriam's assassination, 4 individuals have been named as material authors. One, known by the alias El Aluche, was taken down in a shootout with Tamaulipas Ministerial Police in San Fernando in October of 2017. 2 others remain imprisoned. A fourth, known by the alias El Diablo, remained a fugitive with a 1 million peso reward on his head as of May of 2024. The intellectual authors of Miriam's assassination, the people who actually gave the order, have never been officially identified by the Tamaulipas Fiscalia General de Justicia. Her son Luis briefly took over the collective she founded. It has since largely dissolved. Miriam is honored with a plaque in San Fernando, but the organization she built did not survive without her. It is worth stating plainly that Miriam's investigation, as courageous as it was, almost certainly contributed to her own death. The men she helped capture knew exactly who had put them in prison, and when they got out, they came for her. The intellectual authors of her assassination, the people who gave the order, have never been named by the Tamaulipas Fiscalía General de Justicia. Miriam Rodriguez spent 3 years hunting the people who took her daughter. Jay Maynor did not have 3 years or 3 weeks, or even 3 hours. He had 3 minutes between hearing the truth and getting on his motorcycle. Jay Maynor. On the morning of June 8, 2014, in Coleman County, Alabama, about 50 miles north of Birmingham, Jay Maynor and his adult daughter Julia got into an argument. Julia was 22. During the exchange, something she had carried since childhood came out. She told her father, seemingly in a moment of anger rather than planned disclosure, that Raymond Earl Brooks, her adopted maternal grandfather, had abused her as a child. That was June 8, 2014. By that afternoon, Brooks was dead. Nobody outside the family was paying attention to Julia Maynor. She later told reporters that she could not remember when the abuse started, only that it went on long enough for her to believe it was completely normal, that this was simply what happened in families. Brooks had pleaded guilty to the abuse charges in 2002. He was sentenced to 5 years. He served 27 months. He paid restitution. He was released on parole as a registered sex offender. And then, for over a decade, nothing happened. The system had processed him, checked a box, and moved on. Brooks lived freely in Coleman County, less than an hour from his victim, for years. When Maynor heard what his daughter told him that morning, he did not call an attorney. He did not drive to a police station. He got on his motorcycle. His first stop was a country convenience store, where he fired several rounds at a man who had reportedly been dating his stepdaughter and allegedly abusing her. That man hid behind cover and was not injured. Maynor then drove to the rural home of Raymond Earl Brooks, 59 years old, and shot him twice in the front yard. Brooks died at the scene. Maynor had no prior major criminal record. His daughter described him publicly as the best father she had ever known. He pleaded guilty to both charges, the taking of Brooks' life and the attempted taking of the man at the convenience store. Specifically and deliberately, so that Julia would not have to take the witness stand and relive what had been done to her during childhood. There was no trial, no cross-examination, no forced testimony. He took the full weight of the charges to shield her one more time. At sentencing on August 1st, 2016, in Coleman County Circuit Court, Julia told the courtroom that her father had been protecting her, the way a father should. The court sentenced him to 40 years for the taking of Brooks's life and 20 years for the attempted act at the convenience store. The sentences reflected the severity of what Maynor did, not the circumstances that led him to do it. There was no consideration of diminished capacity, no temporary insanity plea, no psychiatric evaluation entered into the record. He admitted to what he did, accepted the punishment, and asked nothing for himself. Jay Maynor remains incarcerated in the Alabama Department of Corrections. He has served over a decade of his 40-year sentence. A Change.org petition seeking clemency or a pardon from Governor Kay Ivey has circulated online and gathered public support. But it has produced no official action from the governor's office. No appeal has been documented. Julia Maynor has spoken publicly about the case on several occasions, and her statements have been consistent. She does not regret that her father acted. She regrets that the system gave him a reason to. Julia Maynor's abuser served 27 months. Her father will serve 40 years. The math does not add up, and it is not supposed to. That is the entire point of every case in this video. Every parent profiled so far acted against someone who had harmed or was accused of harming their child. The final case is different. In this one, the father did not act against his child's abuser. He acted against the man accused of taking his child's life, and whether that man was actually guilty is a question that will never be answered, because he was gone before his own trial ever began. Bokio Johnson. On March 23, 2022, at approximately 9 in the morning in the Gentilly neighborhood of New Orleans, a white sedan sat at a red light at the intersection of Chef Mentor Highway and Peoples Avenue. Inside were 21-year-old Hollis Carter and his mother, Tokiwa Newman. They were on their way to Orleans Parish Criminal District Court for a pretrial status hearing. A black Ford F-150 pulled alongside them. The driver opened fire with an automatic rifle, striking Carter twice in the head. Carter died at the scene. Newman, in the passenger seat, was gravely wounded but survived. The driver of the truck was Bokio Johnson, a 46-year-old electrician from Bellechasse. At least, that was who investigators believed from the start. But confirming it took time, because there were no witnesses who saw the shooter's face, and the act was over in seconds. Hollis Carter had been charged with the March 28, 2021, shooting deaths of Caleb Johnson, 18, and Brianna Brown, 25, at an Algiers apartment complex. Caleb was Bokio Johnson's son, a senior at Edna Karr High School who had been preparing to enlist in the Navy. Brianna was Caleb's stepsister. The shooting was allegedly tied to a dispute over a firearms sale. Carter had initially confessed to the crime, then later recanted, claiming the confession had been coerced by the actual shooter. After 5 months in custody, he had been released on $375,000 bond. Bokio Johnson attended every single one of Carter's court hearings. He sat in the gallery. He watched the proceedings. He waited. New Orleans police identified Johnson through street camera footage that captured the gunfire coming from a pickup truck registered in his name. Automated license plate reader data, cell phone location records, and rifle ammunition recovered from his home corroborated the identification. During the search, investigators found what prosecutors described as a shrine to Caleb and Brianna, containing an assault rifle magazine, which the assistant district attorney described as a peace offering to his children, as if to say he had gotten justice for them. Tokiwa Newman testified at trial that she recognized Johnson from having seen him at her son's court hearings. The trial began in June of 2024 before Judge Camille Buras in Orleans Parish. The prosecution, led by Assistant District Attorney Stephen Collins, presented the surveillance footage, the license plate data, the phone records, and the shrine found in Johnson's home. Collins argued that the magazine found at the shrine was a deliberate offering, a man signaling to his departed children that he had done what the courts had not yet managed to do. The defense countered that the evidence was entirely circumstantial, that no witness had seen Johnson's face, and that the prosecution's narrative relied on inference rather than direct proof. On June 28, 2024, the jury delivered its verdict. They convicted Johnson of manslaughter, rejecting the prosecution's charge of second-degree murder. They also convicted him of attempted manslaughter for the wounding of Newman and obstruction of justice. The distinction mattered. Second-degree murder in Louisiana carries a mandatory life sentence. Manslaughter does not. On May 16, 2025, Judge Buras sentenced Johnson to 30 years in prison. Carter's family had pushed for a life sentence. His aunt told reporters that the family had been hoping for life, or even the death penalty because, in her view, the act was premeditated. Bokio Johnson is currently incarcerated. The Orleans Parish District Attorney, Jason Williams, defended the conviction in a public statement issued on May 19, 2025, amid criticism from both sides. from those who believed the sentence was too harsh and from those who believed it was not harsh enough. There is one detail in this case that separates it from every other story in this video, and it deserves to be stated clearly. Hollis Carter died before his own trial ever took place. Whether he actually took the lives of Caleb Johnson and Breonna Brown was never adjudicated in a court of law. His confession existed, but he had recanted it. His mother continues to maintain that her son was innocent, that the confession was coerced, and that the real shooter was someone else entirely. Bokio Johnson acted on the belief that the system had already identified his children's killer. The system had only identified a suspect. And in a country where suspects are presumed innocent until proven guilty, that distinction is the one that will follow this case for as long as anyone remembers it. 10 parents, 10 decisions, 10 different outcomes. Some walked free, some are serving decades. All of them reached a point where the law was not enough. Thanks for watching. Click here for the next video.